I got into international criminal law through pure chance. I had no particular interest in international criminal justice, but a man who was a barrister working in the same chambers, the same firm as me, invited me to become his junior in a case at the Rwanda tribunal back in 1999. And I decided that it was an interesting opportunity. It was different from the work that I was undertaking at the time. And when he promised that it would happen in about a year's time and last for about a year, I thought, well, that's not too much time out of my life. And so I was happy to accept. Of course, things don't always work out how it is promised. And in fact, the case didn't come on for 4 years. And when it did, it lasted for 5 years. So that I spent a significant portion of my early 40s living in Tanzania rather than in London. That's how I got into it. Of course, once you're bitten by the bug of international criminal law, it's difficult to get away from it. So when the opportunity came up to join the office of the prosecutor at the International Criminal Court, I was very interested and I took it. But I wouldn't say that the most significant highlight of my career as a barrister has been an international one. I prosecuted in England the first case under the modern slavery legislation to come to a verdict. There was another one which started before but failed for technical reasons. That was the trial of 8 individuals who had held in servitude a very large number, dozens of people, for decades. And the law in England had not been adequate to criminalize that kind of behavior until 2008. And to bring a case under completely new legislation to deal with the challenges of the fact that the witnesses, the victims of these atrocious crimes, were often very damaged people who didn't make ideal witnesses, and to deal with very capable and intelligent defendants who were well represented, and to bring home verdicts of guilty in respect of some of them on some of the charges, which I thought were richly deserved, was something which I then felt and now feel very proud of. I think I want to pick up your use of the word unique there, the unique challenges. The fact that Dominic Ongwen was a severely damaged individual as a result of the atrocious childhood experiences he underwent is not unique. I would say that the large majority of people I have dealt with in my domestic setting have been severely damaged by their childhood experiences. Thank goodness, evil masterminds from nice middle-class upbringings and happy family circumstances are vanishingly rare. The large majority of people who commit crimes, serious crimes, are people who have themselves been the victims of serious crimes. Take sex offenders. A significant minority, I suspect, perhaps a majority of people who commit sexual offences against children have themselves been the victims as children of similar sexual offences. So I don't accept that the Dominic Ongwen case provides a unique set of circumstances. I think it is regrettably a common set of circumstances. On the other hand, of course, there is a striking sociological interest in a case where the defendant is being accused of the very crimes of which he has been a victim, and where his defence is centred upon that fact. We have to be careful to remember that we are lawyers. The court is not a branch of the Social Affairs Department of the United Nations. The court isn't an NGO. The court isn't a repository of the records of the Lord's Resistance Army from the time it was created. The court's job is to determine whether there was sufficient evidence against Dominic Ongwen for him to be safely convicted of the crimes with which he was accused. His background was relevant, in my opinion, was specifically relevant to two issues which could have resulted in his being found not guilty of all charges. It was asserted that as a result of what had happened to him, he had become mentally disordered. And he called psychiatrists, whose evidence was to the effect that he shouldn't be held accountable because he was unable to resist the impulses to commit crimes because his capacity to do so had been destroyed. That argument was rejected by the judges, who heard from other psychiatrists and who decided that, in fact, although Ongwen might well be mentally disordered, that disorder hadn't destroyed his capacity to commit the crimes. It was also potentially relevant to the issue of duress. There's no doubt that he was indeed under pressure. He was a military commander within a military structure. He had orders which he had to follow. The question which the court had to decide was whether a combination of his formal position within the structure of the LRA, combined with the habits which were ingrained in him from the time that he was a child, having been kidnapped by the LRA, meant that he was under such pressure, such duress, that no reasonable person could have been expected to act in a way different from the way that he acted. So the courts did take his background into account, but not in some general sociological way. It focused, as it had to, because it's a court of law, on the impact of that background in respect of legal issues, specific legal issues. And again, in the case of duress, the court made a finding that it was quite sure that although he was under pressure, it was pressure which a reasonable person could have been expected to have resisted. Not least, he had many opportunities to escape, and he didn't take them. We have to break that question up into its constituent parts. Preliminary examinations can last for decades, and some have, at least more than 10 years. We have to remember that the court's function is only to intervene, only to open investigations and ultimately prosecutions where there is a domestic inability or unwillingness. The preliminary examination can be part of, effectively, negotiations between the court and a state party, which will bring the state party to be willing or able to bring proceedings, because the court is saying to it over perhaps a period of years, show us what you're doing, because ultimately, if we're not satisfied that what you're doing is enough, we'll have to take over. But the court can, and in my view does properly, give time for those negotiations to bear fruit. So I wouldn't criticize the court for the length of its preliminary examinations. Investigations, they take as long as they take. Until your investigations have uncovered sufficient evidence to persuade a court that there are substantial grounds to believe that a particular person has committed a particular crime, then you can't bring proceedings, you can't terminate the investigations. And sometimes that takes a very long time. Take the case of Dominic Ongwen. He didn't come out of the bush for 10 years after the arrest warrant. And then there had to be significant investigation because a whole new tranche of evidence had emerged in those 10 years. So again, I don't think that's a very useful criticism. But where the court really needs to pull its socks up, to up its game, is the length of time that proceedings themselves take. I hold no particular torch for Jean-Pierre Bemba. He wasn't my client. But he was at the court for 10 years from his arrest until his ultimate acquittal, found not guilty, but did 10 years inside during the time that was being determined. That is too long. What can be done to make things more efficient? I'm afraid I don't have time now to begin a long list. One thing, the court's proceedings are not intense enough. I forget the number of available sitting days in the Bemba case that the court did actually sit, but it was a lamentably small proportion of the time. I know that there are administrative difficulties. I know that the court hasn't got enough money to run 3 courts in the 3 courtrooms it's got at the same time. But that's what the court needs to look at. And indeed, there's a very interesting judgment in the Bemba case after its conclusion, where the judges acknowledged that the Bemba case represented an unacceptably long delay and said that the responsibility lay with the judges to ensure that didn't happen again. And I think that judgment, that decision, should be on the wall of every single judge sitting in The Hague, because it's absolutely right. I work in the common law system, and all of the trials which I preside over have juries. So the big difference, what makes my job 10 times easier than the job of judges at the International Criminal Court, is that I do not have to decide whether a person is guilty or not guilty. In England, my job is effectively to be the referee. I blow the whistle when I think that things aren't being done properly and fairly. I summarize the law and explain it to the jury, and I summarize the evidence to them. But at the moment they go out to deliberate, I have nothing to do with it. So that's a really significant difference. Of course, if I was a judge in Germany or France, that wouldn't be the case. So there is a greater difference between the work I do now and the work that a judge does at the ICC than there is for many other countries. What's easier, of course, at the ICC is that the judges all have a significant pool of highly educated and experienced legal officers who can help them with their research, with structuring their decisions, with discussing the law, with preparing them for hearings. I don't know how it is in France, Germany, Argentina, or South Korea, but I get none of that in England. I'm on my own. I have to listen to the submissions made by the barristers for the prosecution and the defense, and then make my own decision. I don't get any help with that. So that's another significant difference. I think that's like asking me whether I prefer strawberry or chocolate ripple ice cream. I like them both. I don't think I have to choose.